All right, folks, buckle up. This isn't just another courtroom formality. We're diving into a case of aggravated assault against a public servant. That's a first-degree felony, the legal equivalent of going from zero to nuclear real quick. What would you do if you were facing up to 99 years behind bars?
Court is calling 2022 CR 5615, State of Texas versus Cameron Sell. Can I have parties announced for the record for the state?
Marcus Sanders.
For the defense?
Daniel Navy.
All right, and probation, this is an application. And are you Mr. Sell? Counsel, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Sell, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, I'm going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge. Proceeding on count one, waiving count two.
This is the moment of truth. Notice how the judge carefully lays out the maximum sentence? That's not just legal housekeeping, it's a reality check. Judges do this to make sure the defendant can't later say, "I didn't know what I was signing up for." Smart move or intimidation tactic? You decide.
Any objection?
No, Judge.
Mr. Sell, I'm showing you what's entitled court's admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Okay. You're charged with aggravated assault against a public servant in count one. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison? Did you understand? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor. I believe it does.
Do you believe he's currently competent and was legally sane at the time of the?
Quick breakdown. Deferred adjudication means the court holds off on entering a conviction, kind of like probation with a huge but. If you mess up, the court can still slap you with a full sentence. And here's the kicker. The deadly weapon finding sticks, which makes things way more serious. Would you roll the dice on that deal?
Offense.
I do believe I know.
Mr. Sale, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, state is proceeding on count one. There's $1,000 fine, affirmative finding of deadly weapon, and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor. And just my understanding is that if he was to get deferred adjudication, the deadly weapon finding would be deferred as well. In order to receive the deferred adjudication.
I mean, there's still going to be a finding, an affirmative finding of a deadly weapon, but he'll get the deferred adjudication if I follow the plea.
Okay.
All right. All right. State, is that the plea?
Yes, Judge.
Defense?
Yes, Your Honor.
And did you understand that to be the plea? All right. And I see there's a case number that's been marked through. Has that case already been taken care of?
It will be judged, but it's not part of the plea agreement.
Okay. All right. Showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor. Well, there was a motion to set aside the indictment, but
All right, and are you waiving that motion?
Yes, Judge.
Next, I'm showing you outside the agreement. The state is requesting that your deferred adjudication be for a term of 10 years. There'll be a TAP evaluation, 200 hours of community service restitution, the MRT and defensive driving. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense is charged in count one. How do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Judge, state out for states exhibit 1 and its attachments.
No objection.
Mr. Sale, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence.
This is where the human side of the courtroom shines through. Behind the felony charge is a 19-year-old battling anxiety, depression, ADHD, and possibly autism. Question for you: should mental health struggles lighten a sentence, or should the crime itself outweigh everything else?
To find you guilty. Court will defer finding the guilt if you apply for deferred adjudication. Are you proceeding with sentencing?
We're fine proceeding with sentencing, Judge.
Anything you wish to say on behalf of your client?
Judge, I'd just like to offer defendants exhibits 1 through 6, and I've showed them to the state.
Any objections?
No, Your Honor.
And Judge, what those are, number 1 is an apology letter to the police officers. Exhibits 2 through 5 are various psychiatric, psychological, and counseling records indicating some of his various mental health issues that he's been dealing with in his young adult life. He's been diagnosed with anxiety, depression, ADD, ADHD, opposition and defiance disorder. He hasn't been diagnosed with autism, but it hasn't been ruled out. And some of the psychiatrists believe that he needs further testing to see if that's something that he is dealing with, Judge. He's a young man. I believe you're 19, 18. He's had no violations on his pretrial monitor, Judge. He's never been arrested before he finished his high school diploma. That's defendant's exhibit 6.
This is where the human side of the courtroom shines through. Behind the felony charge is a 19-year-old battling anxiety, depression, ADHD, and possibly autism. Question for you: should mental health struggles lighten a sentence, or should the crime itself outweigh everything else?
You have, and we would ask that you follow the plea agreement.
All right, so are you working? What are you doing with your life right now?
At the moment, I kind of made it hard on myself with this. I kind of told myself, hey, since you got this, it's kind of hard to get a job. So while being on this, I really haven't put too much time in trying to do that because I've been so stressed and talking myself down, I guess.
You need to get a job.
Yes. So I actually have a buddy who just got offered a job recently, and he's going to see if they can get me up in there as well.
Doing what?
Just working at a gas station, ma'am.
Okay. All right. I don't understand the request for defensive driving.
Because of the facts of the discharge.
But I'm sort of like, if somebody's,
I think this may resolve the issue, Judge. He did complete a defensive driving course recently. And so I would ask that he just get credit for that if he shows probation, the certificate.
all right.
He did complete that.
10 years deferred adjudication, defensive driving. There's $1,000 fine that will be probated. Do you have any children? Right. Anger management. No, I mean, I'm assigning anger management courses. And that's based upon the exhibits that's been presented to the court. There's an affirmative finding of a deadly weapon. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived.
And here's the big takeaway. Probation isn't a free pass. The judge makes it crystal clear: work, study, or face the consequences. This case shows how the system can give second chances, but only if you prove you're serious about change. So, did the court strike the right balance between punishment and rehabilitation?
Remaining hours will be waived if you enroll in some higher level of education. If it's college, I will tell you, are required to be full-time. So if you plan on enrolling to college, the court will not waive the remaining of the community service hours unless you are taking at least 9 hours per semester, or if you are in a trade school and obtain a certificate. There's to be regular reporting, regular UAs. If you're drug tested today, what are the results going to be? What are you going to be positive for? And what else? All right. Marijuana is not allowed. You understand? We're going to do the testing for levels. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. They want you to do the MRT. The MRT course is telling you that you need to consider others in your action. It's something that people should learn in kindergarten or preschool. Be nice to everybody. Treat others as you would want to be treated. But you're going to take the course. I'm going to want field visits 2 times per month. Who do you live with? All right.
And fathers.
So here's the thing. You're either going to have a job while you live with your mom, or either you're going to be in school. I don't allow people who are adults to live at home unless they're working, or either they're in school at your age. You understand? All right. Probation, is there anything else?
No, Your Honor.
Is there anything else you need from the court in order to be successful? Show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it, and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you.